everybody, this is Katie Frekhtman, a New York City personal injury trial attorney. And today, it's Friday, it's October 7th. And what I'm doing is I'm going through the last week's questions. I'm going to choose a few of the questions and comments that you guys have left and try to answer them live in a video. I thought that would be a great topic because I'm responding to you guys, the viewers, and what you are asking about, what you really want to hear about. So let's go to the first question. The first question was 7 days ago, and it asks, what can be done if the insurance company offers the full policy limit and the medical bills are much greater than the policy limit? Please help. Should I get a lawyer? Well, I definitely think you should get and consult with a local lawyer. That's always a good idea. Now, if your medical bills are higher than the insurance limit, then it's a clear tender. Obviously, the injuries are also something that you can get compensated for, in addition to the out-of-pocket medical bills. Now, every state deals with medical bills differently. In New York, we have a no-fault state, so we have $50,000 in no-fault benefits that'll pay for the medical bills. And then we also have the bodily injury policy, which is separate. So it's like two different things. But in order to access the bodily injury policy, you have to prove a serious injury, and there are 9 categories. I've done other videos about it. It gets a little complicated. But in other states, it's like a multiple. Sometimes they say like 3 times your medical bills. So it's always different. But here, I mean, clearly, the only way to get more than the policy limit would be to send a demand and say, look, pay me the policy. And if they say no, then in some states there is bad faith law, and you could open up that policy and then you can go for other layers way beyond. And actually, if the policy is open, the sky's the limit. You can get a really big number. I remember reading in a book, there was one case where I think it was a $25,000 policy, and the case ended up settling for getting a verdict of like $45 million just because of the way the bad faith was set up. So it was set up really well. Okay, let's go to the next question. The next question is, hello, I have a virtual meeting with defendant lawyers. What do you think is that for, in your opinion? Well, that's kind of like a very general thing, just if you have a meeting with the defense lawyers. Usually Okay, so this question is, hello, I have a virtual meeting with defendant lawyers. What do you think is that for, in your opinion? Well, if you're meeting with the defendant's lawyers, then obviously your lawyer should be there as well, and they should be able to tell you what it's for. And in fact, they should tell you what it's for. If they're not telling you what it's for, it's not good. But a lot of the times, a meeting like that could either be a deposition, if you haven't had one, where they ask you questions about how the injury happened, and also your injuries, how the injury has affected you and your ability to live your life. So those are usually, that's a deposition. Now, there could be other things. There could be an examination under oath. There could be an IME, although the IME, usually the defense lawyer you'll be with a defense doctor, not the lawyer. It could be a settlement conference or a mediation. Okay, and then the next question is, in my injury semi-truck lawsuit, the trucking company has admitted vicarious liability but denied negligent entrustment. My attorney has a motion for summary disposition in November. Oh, okay, so this is just a comment, actually. Sorry about that, it's not a question. But yeah, that's good. I mean, the fact that they have vicarious liability just means that the employer or the trucking company is vicariously liable for any of their team members, so their driver, anybody else, because it's their employee, so they're vicariously liable for them. And the owner of the vehicle can be vicariously liable for whoever has permission to drive the vehicle, right? The operator of the vehicle. So that's good that they established that. And negligent entrustment is when you give your vehicle to somebody that you know or should know is like dangerous. Somebody who maybe had their license revoked or just got into a car crash, or every time they get into a car, they start drinking, and then you say, okay, take my car anyway. That's negligent entrustment. You can't do that. So they said that was denied, but there's a motion for summary disposition. And a summary judgment is when you decide a case based on the papers. Like there's no issue of fact, there's not even any question for a jury to decide. It's so clear, it's just as a matter of law, you are right. So that's good. If you win that's beautiful. That's going to be a good case. Okay, and then this person says, thank you for sharing. I wish all attorneys was like you. Oh, thank you. Thank you so much. Yeah, I wish, I wish that as well. I wish all attorneys were like more laid back like me, a little bit nicer. It would be a better world. There wouldn't be so many lawyer jokes. So yeah, hopefully. Okay, let's see the next question. The next question is, hi, I just want to see your opinion. I got hit by a FedEx truck. It's 100% their fault. The driver even just drove away after saying, I hit him. It's all on a recording. I had a year of physical therapy and an epidural injection. My case is going to trial. What's the estimate number that pops out from your head? I know, estimate is good enough, boss. Thank you. And he does a laugh out loud face. So yeah, I guess it's hard to say exactly, because I don't know the file. I'm just reading this comment. But I would say from what you wrote, I mean, look, FedEx, first of all, it's going to be at least a million policy, probably many layers beyond that. So you have coverage. I don't know how bad the crash was. Hopefully, not hopefully, but, if the crash was serious, if there was like crushed metal, that makes it more serious. And then if you had all this treatment, a year of physical therapy, you must have been hurt, and you had an epidural injection. That means that you have either a bulging disc or a herniated disc, which looks something like this, where the leak, everything is leaking from the disc. The disc is leaking out from the vertebrae, and then it's touching the nerve roots. So when something like that happens, an epidural is a big needle, and they put that medicine, a steroid, into this whole area, and what that does is it numbs the area and prevents you from feeling the pain. So if you had that, that's pretty serious. I actually handled an epidural case against a trucking company, and I believe we settled for about $145,000 for that. So anything like that would be pretty good. If you can get more, it would be even better, but I wouldn't settle for too cheap. It sounds like you have a pretty good case there. Okay, the next question, is it true lawyer's cut is usually around 33%? Yes, that is a standard contingency fee. And then the follow-up question was, what are the other fees called? I tried researching for the details. I'm not really sure. There really shouldn't be too many other fees. Now, a lawyer who spends money, this known as disbursements, case costs, has to take those back. So for example, if you settle a case for $1 million, you have $1,000 in disbursements, you can take your legal fee, your 33% off the million, which is $333,000. So then about $670,000 goes to the client. But if you had that expenses, meaning I filed a lawsuit, which was $200 here in New York, $210, I filed, I got certified mail, like $4. So you add all that up and you take it off the million and you get reimbursed. So you don't really make money on expenses. You just spend $1, get $1 back. But you're not allowed to just fund other people's cases, clients' cases, because then if somebody was really wealthy, like a corporate, or in some states they do now have, like in Arizona, and I believe in California, there's a bill where they are trying to do that. But in New York, it's not allowed. So a lawyer can't just fund litigation, because then a really wealthy lawyer could just say, hey, come to me, I'll just fund all your litigation, let's just sue everybody, and then we'll make money. And it's not considered ethical. So you just can't do it from that standpoint. Okay, what's the next question? The next question is from the Sleepy Music channel. And they say that, we're not sure if you read the comments that are posting, but I recently just had an injury at work where a concrete pump was tampered with. They removed all the safety switches and my hand was crushed. I was degloved with 2 broken fingers along with a few fractures. Could you give me an idea of what kind of settlement I'd be looking at with the workers' comp and a private lawsuit against the company? I'm located in California. So, that's a pretty serious, very serious case. It's hard to say exactly what kind of settlement. I'm not familiar with workers' comp law in California, but if there is a third-party lawsuit against, for example, this concrete truck, then it could be pretty big. It could definitely be several million, multi-million-dollar lawsuit, because degloving is a really bad injury. That means that the skin was removed from the hand, degloving, 2 broken fingers. Depending on how it heals and whether they can fix it with surgeries, that could be a really big case. That could definitely be a multi-million-dollar case. I would, if you feel free to reach out. I left my number, the 347-566-9595. I have excellent attorneys in California, some of the top trial lawyers in the entire state. So I'd be happy to, partner up with them and help you with that. Okay, the next question comes from Callie Kings. If there is videotape and there's proof without a reasonable thought that you had zero fault in a lawsuit, TBI case, also loss of enjoyment of life, does that help or doesn't matter? Or how does it play a part in your case? So yeah, if there's proof, I'm assuming he means about liability, that you had zero fault. So then it would help in liability. You would prove liability, meaning you're not liable. And the only issue would be how much to pay you for the TBI, which again is also a multi-million-dollar injury because it's a traumatic brain injury. So it's a very, very serious injury. And then I think he said, thank you. You got a really big case sense. I watch you all the time. I'm wondering if you can give free phone advice. I watch all your videos, very informative. I sub. Thumbs up. Okay, thank you. Yeah, absolutely. I told him to feel free to text me at 347-566-9595. I'm happy to just speak with you. We could schedule a call, give some free advice. You know, if I could help you, I could partner with a local lawyer that is really good, vetted, make sure it's one of the best lawyers, and then I could partner with them and handle your case directly as well. Okay, we have Marvin Williams. The next question. Uber ran 2 red lights and was rear-ended. I was a passenger in the Uber. It was my driver who was at fault. I went to the hospital and 3 months of Cairo and 4 months of loss, $20.50 an hour, 40 hours a week. What will my settlement be? So again, that's one of those examples. It's hard to say exactly from just a text, you know. If I could know everything just from like a comment, I would be like omniscient, you know, and nobody knows that. You'd have to really look at the file because there's, the lost wages you're entitled to, right? Whatever amount of time you missed from work. So you're entitled to lost wages. But it's also based on how much the policy is, and also it's based on other more, you know, open questions like what is your pain and suffering worth, because you're also entitled to that, past and future. And you couldn't say that just from this because there's no injury information here, just that they had 3 months of chiropractor. But usually, like if that's all you have, like 3 months of chiropractor and it's more like a soft tissue case, I would say those are usually worth anywhere from like, you know, 20 to 50,000, usually in that ballpark, just for the injury portion. And then of course the lost wages you would be entitled to as well. And if it was the Uber that ran the red lights, then, you know, Uber does have a big policy. So you could feel free to text me as well, and I'd be happy to give you a consultation, maybe help you find someone if you need help. Okay, let's see what other questions we have. Okay, here's somebody who asks, can you please do a video on EUO? So an EUO is an examination under oath. Usually that's done early at the beginning to make sure that you're getting your treatment. In New York, a lot of the times they do investigations because they believe that something is fishy. Like for example, if somebody says they got into an accident in New York, but their driver's license says that they live in another state, known as forum shopping, because you can get cheaper insurance in either upstate New York or maybe out in Pennsylvania. So then they might do an EUO to see, do you really live, is this really your primary address? Or if they are investigating like a medical provider, if you're going to one of these shady physical therapy offices that says, you know, just sign your name 20 times, then, you know, you can stay home, you don't have to come. They might want to ask you questions about, okay, what happened when you went Monday? What happened when you went Wednesday? What did the doctor do for you? How did the doctor, what test did the doctor do? Did they do this test? Did they do that test? What equipment did they have? And they're trying to verify if you really went or if this doctor is maybe doing something fishy, something fraudulent. So that's usually the purpose of an EUO. But maybe, you know, I'll take a look. I'll do a little research, and maybe I'll do a separate video just about EUOs and cover all the topics there. Okay, let's go to the next question. The next question is, I had a C4, C7 fusion on June 3rd. I had an issue with the nurse at first. She was just rude, and I didn't see my doctor until later. And then I got physical therapy, and I signed up for, but the fusion has not helped me, and it's much worse before the surgery. My scar is so deformed, it makes it impossible for me to even turn my neck, and I can't eat without choking, and the surgeon even said it's the worst he's ever seen. So I think what she's saying is that she has a potential medical malpractice case against this surgeon, that she thought she was just going to get a simple fusion, and the fusion led to the scarring and all these issues. So in order to evaluate that, what we would need to do is get the medical records, right? All the medical records, we would need to read them, and we would need to work with a doctor that's an expert, maybe another doctor who does fusions, and then he would have to, or she would have to review it and tell us if they found a mistake, that if the first doctor made a mistake. And if they say, look, this is a case of potential merit, then at that point, we could file a lawsuit and then we could prosecute it. So yeah, it's kind of, again, I think I said definitely get all the medical records, right, and maybe review that, and either with a local lawyer, I don't know where the person is, commenting from, or if it's in New York, we could do it. Okay, now here's the next question. If you're doing Uber Eats and slip and fall in a McDonald's, can you sue for damages? Yes, I believe you can, because if you're doing Uber Eats, and you're in a McDonald's, you're not an employee of that McDonald's, so you should be able to sue. If there was negligence, if somebody left like a puddle, you should be able to sue either the McDonald's or maybe the cleaning company, if it was an employee or if it was an outside cleaning company, any third party. Usually you just cannot sue your employer. Okay, here's a question. The next question, what about AC diffuser falling and hitting someone in the head? Oh, I see. I think that was a comment about the video I did earlier this week, which was about ceiling collapses. And this person is talking about what if it's not a ceiling collapse? What if it's an AC diffuser? Well, yeah, I mean, it shouldn't be falling, right? I don't think AC diffusers are supposed to fall on people's heads. So as long as it's any kind of negligence, and in fact, there's something known as res ipsa loquitur, which basically means the thing speaks for itself. And so if something just cannot happen without negligence, that's res ipsa, and that's just as a matter of law, you win. So that should be a great case. Okay, let's see the next question. I'm an Uber driver. I was involved in a four-chain reaction car accident. Last car was determined to be 100% at fault, but doesn't have enough insurance coverage to support the claim. The claim exceeds the limits of the policy. What would be my options? At the time, I had a passenger. So yeah, that's, I'd have to look into that. So if he's the driver and then the car that hits him, the final car, doesn't have enough coverage, but we'd have to see what the injuries are. So it also, like the prior question, you could send a demand letter. I call it sometimes running with the bulls. You basically tell them, look, give me your policy, tender everything. And if they say, no, we're not tendering everything, we're not giving you everything we have. So then, okay, fine. So you had 30 days to give me everything you have. You didn't. That was your choice. Now I don't want it anymore. I just want a jury trial. And in some states, that's bad faith. You open up the policy, and now if that jury trial gets more, like $1 million, $2 million, whatever it is, their policy is open, meaning that cap that they had, not enough, like in your question, doesn't apply anymore. That cap is not there. It's open. So now you can get more. So I hope that was helpful. There's also like underinsurance. There's a lot of other things you can do if your insurance is higher. But yeah, there's bad faith and there's underinsurance. Here's the next question. As the plaintiff witness of a civil suit, can you do your own investigating when you have counsel? Yeah, usually the counsel should be doing it, but you could do your own, like, for example, interviewing witnesses if there was a car crash and you know who the witnesses were, or slip and fall. Like, for example, if you live in a building and you have a slip and fall in an apartment building, well, obviously, the witnesses probably better than any lawyer, right? Because you live there. So you can then, maybe knock on doors, talk to your neighbors, friends, and say, hey, have you ever seen this puddle or whatever the condition is, this leak from the ceiling? Have you ever noticed something like this happening? And then you can gather witnesses, give the witnesses to your attorney. So that's always a good idea. Okay, the next question. Great video. Thank you. Okay. This is exactly what happened in my case and led to me having spinal fusion surgery with the hardware. I have the best trial lawyer and feel very confident they'll be able to get me fair value for my injuries. The most important takeaway from watching your videos is to retain the best trial lawyer versus just a settlement lawyer. Yes, absolutely. I agree with you. I don't know. I have to check. I have to see which video he's referring to. It doesn't say here when I look at all the comments, but he's absolutely right. You have to get a trial lawyer. And there's a big difference between a trial lawyer and a settlement lawyer. A settlement lawyer is just doing volume and they just want to settle. So they could be settling your case for like $20,000, whereas a trial lawyer, if you have a more serious injury and they look for other layers of coverage, they do a deep dive, you can be entitled to much, much more. It could be like, the difference could be dramatic. It could be over $1 million versus like 20,000. So definitely don't go for a settlement lawyer. And then we have another question from Ricky Harris. Now, I think this is just a comment. Let's see what else is. Here's a question from War Prince. How long does a case like this last for a friend is about to hit 1 year and 4 months and nothing is being told to the family by the attorneys? Well, a case could take 1 year. 1 year is not necessarily a long time, if it's in litigation especially, but the fact that he's not being told anything, that's a big red flag. You don't want that. You want to be able to call the lawyer, make an appointment, speak to them on the phone, text message, whatever, email, but you want to have communication. And then we have a question from Far Real. I had a slip and fall in the hospital. I initially went in the hospital with my foot and had my toe amputated. They discharged me and didn't provide me a wheelchair. I fell and ended up herniated my disc in my lower back. I went through all the treatments and took 4 epidural shots. Now I am going to get surgery next week. I lost my job and in so much pain. I hope I can get half of what this guy got. Oh yeah, he's probably commenting on another video I did about that case out in California where somebody got $10 million. And he's saying, I hope I can get half. But yeah, he definitely has a serious case. That's definitely a strong case if he had to have his foot amputated. He said it was a slip and fall. I don't know the liability. I would ask that. How did it happen? Who was at fault? Let's look into the liability. Maybe we need an expert. And then when he fell, it ended up herniating his disc in his lower back, and they didn't put him in. They didn't give him a wheelchair. Now that, I don't know if that's negligence, not giving you a wheelchair. That might be more like medical malpractice, possibly, if it's like the doctor's decision, medical decision, that you don't need a wheelchair, but you really did. But that's kind of like a tough case. But he went through all the treatments. It took 4 epidural shots, and now he needs surgery. It doesn't say what kind of surgery, but it sounds like if he had epidurals, it might be like a discectomy or a fusion. So it sounds like a very serious case. And the other thing I'd like to point out to Mr. Fa Real is that, you know, you don't have to necessarily have 2 separate cases here. You don't have to sue for the slip and fall and then also sue the hospital for not giving you a wheelchair. What you could do is you could just sue for the slip and fall, and everything else that happens is foreseeable. So the fact that, you know, a doctor may make a mistake is foreseeable. Under New York law, at least, under the pattern jury instructions in New York, we have that charge. And then you could, it's known as natural sequelae. It all flows from this slip and fall, right? That was the original thing that caused your injury. So then you get all your damages after that. So it's actually better for you. So if this is a New York case, yeah, feel free to text me, or even if it's not, I could maybe put you in touch with a local lawyer if you need a lawyer. Okay, and then the next question from Ricky Harris. Are reserves like an umbrella insurance as well? No, reserves aren't really an insurance. An insurance is more like a policy. What reserves are is just like the highest amount that the insurance company may have to pay. So usually it's within their policy. So for example, if they have $1 million policy, they could set reserves at $1 million, you know. But if they have $1 million policy and then many, many layers of excess, they might have like 100 million in excess, right? They might not set 100 million aside as a reserve, right? That you're going to hit them for 100 million. They're going to have to pay you the 100 million. But they'll set aside a reserve based on your injury. So if your injury is like, for example, like a soft tissue injury, they might say, okay, you know what, how much is he possibly going to get? Let's set reserves of like 200,000. It's unlikely we're going to have to pay more than that. But, you know, you never know, because then the person might go and have a fusion. And now they might say, you know, 200,000 is not enough. Now let's set reserves for like 5 million because he has a fusion or she has a fusion. They might be worth much more. So that's how reserves work. But they're not like a separate policy. They're more like a risk analysis by the insurance company to protect their own money. Then we have Matthew, who sent a picture of a goat. Oh, wow. Thank you. I think that means he likes it. Okay, awesome. Thank you so much. And then we're getting into the final questions now. What are the insurance limits when it's a premises liability case? Well, most apartment buildings or, you know, commercial structures are going to be $1 million or more. Some buildings, if it's like a house, like a small one-family house, could have homeowners for less, like 300,000. But usually, for the most part, it's high limits. So those are good cases. And then the next question, I fell inside the door of an MTA bus on my knees. The driver didn't pull to the curb of the bus stop. He stopped in the street and didn't lower the bus. I got up, paid my fare, sat down. Upon reaching my stop, I noticed it was difficult getting up, so I went to the emergency room. The hospital was a 5-minute walk. I'm not in therapy, but I did an MRI on my right knee and back. I have another MRI for my left knee. I need a lawyer. Okay, yeah, absolutely. Give us a text. We're going to call her back and speak to her. That could be a case because, yeah, they do have a duty if someone is like elderly especially, or they're disabled and they need help and they say, hey, can you please lower the bus? Or sometimes the bus driver just has to do it on their own if they see who they're dealing with, you know, just using their discretion, be reasonable and lower the bus. And also, she had a fall inside the bus. So that just depends. If he didn't pull up to the curb, he was not in a safe spot. If she's walking to the bus and she wasn't able to get on the bus and she fell inside the doorway. So that could be a case, depending on the injuries and depending on how much treatment. And now the final question. Okay, the final question is: I wish you worked in Phoenix, Arizona. And actually, you know, we don't, but we do have local partners in Phoenix. We actually just, I believe, referred a case to a local lawyer, and we're going to partner with them on a case in Phoenix. I was out in a retreat for trial lawyers back in last summer. And there was a few lawyers there, one lawyer from Phoenix, a very good lawyer. So yeah, I have access to multiple lawyers, but definitely in Phoenix, we're pretty much hooked up there. We can get a good lawyer, one of the best trial lawyers for you. So it's not a problem. Okay, I hope this has been helpful. Let us know what other questions you have. And if you like this kind of weekly series, just keep leaving the comments about what you want to see. And I'll keep doing this. Maybe I'll do it like once a week or once every few days, depending on how many comments we get. And we can answer your questions through a video. Okay, hope everything is great. Have a great weekend, and I'll talk to you very soon. Bye-bye. you.